saying that those criteria are not clear at all?
No, I mean, there have been some very general considerations articulated by the Justice Department, but the logic under which the USS Cole bombers would be tried in military commission, but the planners and perpetrators of 9/11 would be tried in domestic court, frankly, escapes me.
Mm-hmm. Now, looking back at 2001 and the initial Supreme Court cases that came out of that, and then looking at the situation as it is today, can we say we are in any way better off or worse off, or it was pretty clear at the beginning, the issues seemed to be pretty clear cut, and yeah.
Yeah, I would say before the Supreme Court decisions beginning in 2004, the issues were clear cut, and the law was on the side of the Bush administration. There were precedents from World War II endorsing the use of military commissions by the president unilaterally, and there were precedents holding that neither the Constitution nor the habeas statute applies to aliens held outside the country as enemy combatants. The Supreme Court has reversed itself on a lot of those propositions. I don't think the country is better or safer as a result, but the law is what it is right now.
You're saying the law is what it is?
It's more favorable to detainees, but
yes.
There is nothing in any of the Supreme Court decisions that would prevent use of the military commission statute in order to try Al-Qaeda members for war crimes. There was a 2006 Supreme Court decision which held that the president had not adequately explained his decision to use military commission procedures that were different from court-martial procedures, and that the details of that should be spelled out by Congress. In response to that decision, there have been not one federal statute enacted, but two federal statutes enacted, one in 2006, signed by President Bush, and one in 2009, signed by President Obama, which spell out in great detail the procedures to be used for military commission prosecutions. Mm-hmm. Procedures agreed to by the legislative branch and the executive branch, which are collectively the political branches responsible for fighting wars. There is nothing in any Supreme Court opinion casting doubt on the lawfulness of those procedures to be used in trying these detainees.
How does one then explain that there is this still ongoing debate about federal courts and this is really the way it should be done, and there seems to be really just one opponent, vocal opponent, Senator Sessions, who has his thoughts pretty well carved out, but everyone else tends in the direction of federal courts are really the ideal of American fairness.
Well, the debate is primarily a policy one, not a legal one. The Obama administration has not said that using the military commission procedures that the president himself signed into law would be unconstitutional or otherwise unlawful. Mm-hmm. What they have said is that domestic courts are preferable on policy grounds because somehow they better reflect our values, and somehow if we use criminal process instead of military commission process, Al-Qaeda will magically recognize how wonderful the country is and stop trying to attack us. That doesn't seem to me a very plausible argument, but in response to your question, it's a policy argument, it's not a legal argument. I don't think there are any serious legal objections against using the military commission statute as currently on the books.
How do you see the future of this debate, given that it has been very erratic recently and has shown a significant lack of preparedness in response?
Well, as I said, the administration seems to be moving away from bringing the most dangerous Al-Qaeda members in our custody into New York City for a very expensive and dangerous trial that would give those members of Al-Qaeda a very large soapbox from which to spew propaganda. I hope that continues. I hope they reverse that decision, and I hope they move in the direction of trying detainees before military commissions wherever they can.
Okay. Well, we hope you know something now that you didn't know before. Thanks very much for watching us, and tune in again next time.
Cut.
Successfully.
Okay. Is there any example you can give?
I could, I could talk about it a little bit.
Yes.
If
Okay.
you want.
Okay. Okay. So, I think. Okay. So yes, we can. I think we have about four more minutes.
Yeah.
Yeah.
Between 3 and 4.
Yeah.
Are you ready?
Mm-hmm.
We're
Okay.
going to set 5, 4, 3.
Okay. Are there any examples of a legal argument that has been successfully made on either side?
There have been detainees who have tried to stop military commission prosecutions under at least the 2006 statute. When I was in the government, we defended against some of those challenges, and all of the judges rejected the challenges and allowed military commission prosecutions to go forward.
But what type of challenges were those?
Challenges to the constitutionality of the military commission statute, the one in 2006 at the time that President Bush had signed. Those challenges would become even harder today because now there is the 2009 statute signed by President Obama, which affords defendants even greater protections than had the 2006 statute.
Okay. Any instance where the argument went the opposite way?
None that I know of.
Okay. Great.